This is Left Voices for Friday, February 28th, 2014. I'm Andrea Sears. Tonight,
this is not the way we should be having this debate in this country about the government's authority to kill without due process, without charge and trial by its own citizens.
Anonymous officials say another American is being targeted for death by drone. Abdullah al-Shami is the name White House sources are using when talking about a U.S. citizen allegedly living in northwest Pakistan who they say is a candidate for a targeted killing by drone strike. Unnamed sources within the Obama administration first cited in an article in the Associated Press 2 weeks ago and again this Friday in the New York Times say the administration is deliberating whether or not to authorize his execution. His true identity is apparently known, but has remained classified. Al-Shami may have been born in Texas. His family apparently moved to the Middle East while he was still a toddler. They say he married the daughter of a top al-Qaeda leader, that he appears to be one of al-Qaeda's top planners for operations outside of Pakistan, and there is evidence that he's involved in the manufacture and distribution of improvised explosive devices, or IEDs, the weapons responsible for the deaths of many American troops in Afghanistan. But that's about as specific as the publicly available information gets. Al-Shami would not be the first U.S. citizen to die in a targeted killing. Muslim cleric Anwar al-Awlaki was the target of a lethal strike in Yemen in 2011. Samir Khan, another U.S. citizen, was killed in that same strike. 2 weeks later, Abdulrahman al-Awlaki, Anwar's 16-year-old son who'd gone looking for his father, was killed in yet another drone strike, though he was not the acknowledged target. And one other American, Jude Keenan Mohammed, was killed in a drone strike in Pakistan. The Obama administration's claim that it has the legal authority to kill a U.S. citizen without charges or trial has caused alarm among civil liberties advocates. But Pardiss Kebriaei, senior attorney at the Center for Constitutional Rights, says the entire targeted killing program is based on still secret and highly questionable legal analysis.
This is a program that has been going on for years that has resulted in the deaths of over 3,000 to 4,000 people in multiple countries. And what the government has to say about it has been only in the broadest of strokes, the broadest outlines of its legal reasoning for what it is doing. It has provided no data about who it has killed, why it has killed them, where it has killed them. Everything we know comes from the media and advocates on the ground in terms of data. So just as a basic starting point, I think the continuing refusal of the administration to say more about what it is doing and to explain its actions and provide information is unacceptable given the authority we're talking about here, which is to kill. It's the most consequential authority the government could claim. In terms of this particular individual, what we know is we have a name, we have some cryptic quotes from anonymous officials, and we know that he's in Pakistan. As far as the law goes, outside of battlefield situations, outside of actual war zones, the use of lethal force against a person without charge and trial is only permissible in the face of a specific and imminent threat, and where lethal force is a last resort. There are serious questions about whether that standard is being applied here. I say that, one, because, again, we don't have the legal memos, the legal reasoning the government has used before in justifying its killing of the last U.S. citizen, Anwar al-Awlaki. What we do have is, for example, a leaked white paper summarizing a legal memo from that killing that basically defined away the imminence requirement. It said the circumstances under which the U.S. could target and kill a U.S. citizen outside a situation of active hostilities would be permissible if the person presented an imminent threat, capture was infeasible, and other criteria. But as far as imminence, for example, it said that imminence does not require clear evidence of a specific attack in the immediate future. So in other words, imminence doesn't require imminence as far as what we know of what the Justice Department, anyway, has said in prior reasoning. So context in this broad program is important to think about. But as far as this individual, there are serious questions about the standard being applied against him in Pakistan.
The White House is essentially leaking this information. It's all anonymous White House sources that have given us what information we have, either through the AP article or now through the New York Times. Is this a way of testing the waters, trying to determine public opinion, or giving a heads up that they intend to kill an American citizen?
I don't know. This is how the targeting began for Anwar al-Awlaki. But bottom line, this is not the way we should be having this debate in this country about the government's authority to kill without due process, without charge and trial one of its own citizens through a New York Times article or AP articles and anonymous statements from administration officials. We need to know, years after this program began, thousands of deaths later, what exactly the legal standards and interpretations are upon which this authority is being based. We have at this point a leaked summary of a memo that came out last year. We have speeches administration officials have made over the past year and a half, 2 years. We have most recently a new policy guidance, which is about new policy standards, not legal standards. The administration says it is using or is going to use in conducting these strikes. But what we know about that policy comes in the form of a fact sheet, a one-page fact sheet about a killing program. And that sort of speaks for itself, given the gravity of what we're talking about here.
And is there any opportunity or means to challenge the proposed targeted killing of al-Shami?
When the administration announced its plan to target kill Anwar al-Awlaki several years ago, we did with the ACLU file a lawsuit challenging that authorization and arguing not necessarily that the government could not take action, but that if it were going to kill that U.S. citizen, it needed to follow the law. And the law, as far as we put forward, is that outside of a battlefield situation, the use of lethal force is only allowed in the face of a specific and imminent threat and where lethal force is a last resort. And we argued back then that putting someone on a kill list and deliberating about their killing weeks in advance flew in the face of the requirement of imminence. I think that argument applies here as well. The administration has been debating whether to kill this person. I think if you accept that imminence means imminence and that lethal force is only permissible if there's an imminent threat at the time lethal force is applied, those circumstances really undercut that requirement. So I think the same arguments apply, certainly.
The Center for Constitutional Rights has a lawsuit, al-Awlaki v. Panetta, on behalf of the father of Anwar and the grandfather of Abdulrahman al-Awlaki over the killing of Abdulrahman and his son, who was apparently not a target. But what have you been able to learn so far, or have you been able to learn anything about the policy, the legal justifications, or anything else that you're seeking in this lawsuit?
The government's position in our lawsuit is part of its broader position that it does not believe that the judicial branch has any role in determining the legality of its conduct, including when it takes action against its own citizens. So the government's response to our lawsuit, which, as you said, is on behalf of Nasser al-Awlaki, who's the father of Anwar al-Awlaki and the grandfather of 16-year-old Abdulrahman al-Awlaki, as well as the family of Samir Khan. The government's response to that has been to move to dismiss the lawsuit on threshold grounds, but basically say that the court should have no role in reviewing the family's claims at all. These are constitutional claims that allege that these killings that were authorized and directed by senior officials in the administration violated the fundamental constitutional rights of these individuals to due process and under the Fourth Amendment. So they filed this motion to dismiss. We responded. We had an oral argument last summer, and we're now waiting for the court's decision.
Pardiss Kebriaei is a senior attorney at the Center for Constitutional Rights. This has been Left Voices for Friday, February 28th, 2014. Join us again next week for more news and information from a progressive perspective. I'm Andrea Sears for leftvoices.net.